Welcome, everybody, to our first official weekly immigration news recap. I'm here with my friends Dan Maranci and Matt Gale, and I'll let them introduce themselves in just a minute here. But this is an extension of Lawfully's bi-weekly Immigration Insider series that we started doing back in April. So if you're not familiar with that event or a meeting, as we like to call it, every 2 weeks, Matt and a special guest co-host who we're calling an immigration insider um, comes to this meeting. We invite a bunch of different immigration attorneys and other professionals in the space, and we have a two-way conversation about what sort of the hot topics are in immigration news. And then we bring attorneys on to share their perspective, their point of view, and ask Matt and our insider questions. So we actually just yesterday had our third session with Doug Rand, who is the former senior advisor to the USCIS Director under Joe Biden. And while we were recording that, actually, the new USCIS Director was testifying, or excuse me, not testifying, but was in his confirmation hearing with the Senate Judiciary Committee, and that's going to be what we talk about today, along with some other headline news. So I'll welcome our guest co-host for this week, Dan Maranci, who's a former colleague of mine. Dan, can you tell everyone where you're from, what firm you work at, a little bit about yourself?
Sure. I'm currently at WR Immigration. I'm a partner in the Boston office. I previously was at a few other firms running very large programs, which is a fun kind of experience. One that I don't know. Thankfully, they don't come around all that often, but you learn a whole lot from it. I'm also on the AILA Innovation and Technology Committee, so I've always been one of those lawyers that, likes to meddle in technology and process, and in part because if you're doing high volume, you kind of have to take advantage of every tool that you can possibly get your hands on to survive, especially during crazy scaling periods. So that's kind of my thing. My focus is obviously business immigration, so I'm very happy to join you guys and talk about the latest challenges we face in our profession.
We're happy you're here, and we're happy you always join us on the Immigration Insiders meeting and share what you're seeing and share your point of view. And you always come ready with opinions, which we appreciate. Um,
Yeah, never been accused of not having opinions.
And if you're listening to this on our real-time immigration podcast feed, you'll recognize Matt Gale, Chief Strategy Officer at Lawfully. But Matt, you want to just let the audience know, if people are watching this on YouTube, who you are and what you do?
Thanks everyone for joining us. We are stoked to be doing this and to be able to drill in a little bit more to the news that's happening every day. It's hard even for us working in immigration and following it all the time to stay on top of it all. So we're excited to bring this new series out and be able to share some of these insights with all of you. And Dan, thank you so much for joining us. I started my career working in immigration nearly 10 years ago because my wife is from Costa Rica, and we went through the process to get her green card, and I ended up joining a small startup that got acquired by Fragment in 2020 and spent some time there, spent some time at another major corporate immigration firm, Barry Appleman and Leiden, or BAL, and a little over a year ago, joined Lawfully to help build out Lawfully Pro, a software solution for immigration lawyers to stay on top of their cases and to improve the experience for the foreign nationals that they work with that are going through a often opaque government process. And so we're really happy to be sharing some of these insights with you, and grateful for you, Finn, for putting all this together and making it happen.
Yeah, thanks, Matt. And there's probably no other non-attorney who speaks to immigration attorneys more often than you do. So you always have a pretty good finger on the pulse of what immigration attorneys are dealing with and thinking about. Because I see your calendar and I know how often you're on calls with immigration attorneys. We'll
I
jump.
still, it's like every day though, I'm still learning something new,
Yeah.
and I feel like I know a lot about certain areas of immigration law, but other areas I'm like, whoa, I did not even know that at all. Yesterday, I was meeting with a firm that's very specialized in H-2As, and I was like, oh man, I don't know very much about H-2As. I need to learn more about H-2As.
Yeah, it's a bottomless pit, immigration policy. And then the reason why we started this particular series, where you and I and we're bringing on a guest attorney every week, to recap the news is because the pace of change under the Trump administration has just accelerated so much that and that'll allow me to jump right into our first housekeeping item. So we're gonna release these episodes every Friday morning, as sort of again a weekly immigration news recap. But we're recording them at about 10:25 Eastern time on Thursday. So if anything changes between now and tomorrow when we release it, which we think will probably happen, we'll cover that in next week's episode with our next guest co-host. But the way we'll do this is we'll just run through three of the biggest news stories in immigration that happened this week. And then we're actually going to pull up some clips from Joseph Edlow, the nominee for to be the next director of USCIS. We're going to pull up some clips from his Senate Judiciary Committee nomination hearing yesterday. And then at the very end, Dan's going to tell us about a story that or a trend that he thinks is not talked about enough right now in the immigration space. So that's how we'll run through it. So first story, Ayla reported this on Tuesday, excuse me, May 20th, that they're getting reports of more rejections, RFEs, and denials coming in because of signature issues. This is something that if you were in the immigration space during the first Trump administration, you'd be familiar with, but it appears that USCIS is starting to sort of reinstitute that. So Dan, any reaction to Ayla reporting that that's coming back?
Yeah, and I've heard from colleagues and from other practitioners that they're seeing exactly the same thing. It's one of those things that, technically, can they do it? Sure. If you read the instructions, there's no real way to read them without taking away, and what the general practice is for the larger volume folks is what you'll typically do is send sort of a white piece of paper to the person that you want to sign the forms. Then they'll put their actual ink signature there, scan it, and then you can place it on the forms. Under the prior administration, it's not as if there isn't a process in all of the large volume practices to actually acknowledge that the person whose signature is going on actually approves of all of the content in the form. You'd be crazy not to have a mechanism where they very explicitly authorize you to do that and confirm that the information is correct, right? So you have something that under any other normal, like any other legal process, I think they'd typically accept something like that as fine. There's DocuSign too. That's not even a reproduction of a wet signature. It's an authorization, though, that we all accept because, let's face it, it's a more efficient way to conduct business, and it's pretty secure. Anyway, what the instructions to the forms say, in particular I-129, is that if you're going to send in a photocopy, it has to be of the wet signature, and then they use, I think it's the specific words, on the document, right? So if you're doing that and taking a snip, like a PDF of a signature, and then, placing it digitally onto the document, that is not a wet signature on the document that has been photocopied. I think that's just the sort of technical reading. What I have not heard is whether the responses to these noids have been successful. And if I was going to respond to one, I would probably include some kind of affidavit from whoever signed it saying, I authorized this, maybe some kind of chain of proof that you did authorize it when it was right before it was filed. So the email saying, hey, looks great, or if it's through some kind of case management system, whatever the whatever the prompt was that they answered, there'd be a log of it, print out of that. And then I'd probably reference the fact that you don't need a wet signature for an H-1B electronic online filing. So what does it matter?
Yeah,
Again, though,
that's a COVID era rule, right?
Yeah. Yep.
Yeah.
So, but they could still come back and say, hey, but the strict language of the instructions, which are, have the force of a regulation. Sorry, it was not a copy of a wet signature on the document. So we'll see. It's kind of a silly reason.
Why do you think, Dan, why do you think they're doing this? I remember when I was a simple citizen in the first Trump administration, I remember the massive uptick that we saw of rejections for every minor little thing. And we had to put some pretty clear instructions together for the specific things that we were seeing, whether it was issues with the placement of the forms, the checks, the passport photos, the signatures, things that previously were maybe overlooked. Do you think this is all under like their additional scrutiny executive order? They're just saying, what can we scrutinize, and let's scrutinize it more.
Yeah, I think so. I think, and if anything, they had the template for it from the first administration. It's really purely an effort to slow things down, to show that you have, I mean, I assume if your entire, the gist of what you're trying to accomplish is to both slow down and decrease immigration, that's one very easy way to do it. And they probably know that the large programs, to just sort of have the process in place that's efficient enough to get like 200 H-1Bs out in a week, you kind of have to do something like this. So that will slow it down 100%.
I said this yesterday on our Immigration Insiders with Doug. There aren't many people that are happy about this kind of news, but there are two types of organizations that are. UPS and FedEx and all the printing companies. They're making us double print everything.
Yep, exactly. And, so we'll see. I think most are starting to pivot to photocopies of wet signatures. You try to come up with as many workarounds as you can. In some cases, back when we were first looking at this, a lot of client teams would do things like pre-print a bunch of forms, because there's only a few where you have on the form itself something. In fact, I think it's only the passport details of the FN, and I think it's on the I-129H maybe. I don't know. It's one of them anyway. But the rest of them, you could just pump out a bunch, send them to your client, have them wet sign a whole bunch of them, and then come up with some kind of numbering system so that when you insert that page, you can reference it back should they RFE or NOID it for the wet signature, and you could actually provide that specific wet signature.
Really quickly on our two other stories that I want to cover, we can actually I'll give the headlines, then we could segue it right into Edlow's hearing from yesterday, because he touches on both of these. This week on Monday, Supreme Court announced that DHS is basically allowed to terminate TPS for Venezuelans specifically. Since the Trump administration came into office, they've announced terminations. DHS has announced terminations for Afghans and a few other groups as well. But the Supreme Court seemed to uphold that that is not a problem. That's something that the Trump administration can continue to do. And Edlow, in the hearing, as we'll listen to in a minute, spent a lot of time speaking against TPS, specifically the TPS programs that were set up under the Biden administration, and claiming that they were unlawful. Another trend that popped up, it was reported by Inside Higher Ed late last Friday. Of course, there's always the Friday news dump with the Trump administration. Friday evening or Friday afternoon news dump. ICE has reportedly begun revoking or sending notices of revocation to F-1 OPT holders, which follows the wave of SEVIS revocations we saw in April of F-1 students. But now they're we'll go into the details in a little bit here. Now they are beginning to scrutinize exact timelines for when F-1 OPT holders report their employment in the SEVIS system, and if that isn't done in time, they're really not giving any grace. So we'll touch on both of those in a minute, and I actually will pull up the first clip with Edlow here.
While you're doing that, Finn, I will say with these TPS terminations, we've seen at Lawfully that folks that are on a temporary, maybe less durable status, we've seen they are doing their best as a community to come together and to look for alternatives to lock in a more durable status. And so we saw a lot of parolees, a lot of folks on TPS that if they were eligible, they were going down the asylum path. They're filing 589s and they're starting an immigration court case. If they're eligible, if they've married a U.S. citizen, they're eligible for a green card through that. Then they're doing that. We've seen a big uptick in folks that had a form of eligibility and are locking in a more durable status. And the unfortunate thing is that there are many folks, these Venezuelans, Afghans, and folks on parole that maybe aren't eligible for something. And so for those folks, that's where I think litigation comes in. You say, well, what else can the law do to protect these folks that were given a benefit from the federal government, that were guaranteed this benefit from the federal government, and had the rugs pulled out from them? And they're great organizations doing that work, and hopefully we'll see further action. It's some of these cases are going to the Supreme Court multiple times with different interpretations.
Absolutely. And people wouldn't, normally think that the TPS stuff impacts sort of the world of corporate immigration, but Dan and I were talking to a friend who's at one of the large firms who represents a lot of construction companies and massive, multinational construction companies, and they employ a lot of individuals who are here on TPS. So that's going to be a big problem for them, and it's going to be something that hopefully they, let their voices be heard on it, because I'm not sure with a lot of things as the Trump administration moves so fast that they're aware of the reverberation and the effects that these sort of swift actions are having on American companies.
And
Uh,
it's similar with parole. I know a friend that has a steel company in Utah, and many Venezuelan parolees that are working with him. And there was I think it was a 60 Minutes where they were talking about some of the Haitians working in the Midwest, and they're powering a lot of the manufacturing economy in the Midwest.
yep. All
Haitians
right.
that are on parole. Yeah.
This is a clip of Senator Mike Lee from Matt's home state of Utah, a Republican, who's going to be asking Edlow about F-1 OPT. And listen closely here, Dan. I'm curious to get your reaction to it, because he says something that I don't think I had ever heard was on the agenda of the Trump administration. So I'll play it now.
Start with you. The Biden administration turned a lot of things on their heads. One of the many things they turned on their heads involves the optional practical training program, and they turned it into the single largest guest worker program, bypassing the traditional limitations, the traditional rules that would otherwise apply by operation of law on other visas like H-1B in the United States. What changes would you plan, if confirmed, to make in order to fix that issue?
Thank you, Senator. I think the way in which OPT has been handled over the past 4 years, with the help of certain decisions coming out of the D.C. Circuit Court, have been a real problem in terms of misapplication of the law. What I want to see would be essentially a regulatory and sub-regulatory program that would allow us to remove the ability for employment authorizations for F-1 students beyond the time that they're in school.
All right, Dan, remove the employment ability for F-1 students beyond the time they're in school. What do you think of that?
Crazy.
Wonderful. Wouldn't that be great? Yeah. So many tech companies will be so appreciative of that. And I mean, it's none of it's surprising, really. And I think this has been floated multiple times over the years, typically by restrictionists. Let's get rid of all of OPT because, they're taking the jobs that, U.S. workers, would be filling. But I mean, all of it runs completely counter to the reality that, I think the percentage of international students that are in STEM, I think, is pretty substantial. So I think just simply, shutting that down, I don't even know how you would do that.
Yeah,
Right?
so that's what I wanted to ask you about, is because in theory it's codified in the CFR. So in theory, a new rule would need to be proposed through the proper channels. There need to be a period of public comment. Obviously, there would probably be some litigation. Not probably, there would definitely be litigation if USCIS proposed, straight up eliminating or significantly decreasing the ability of F-1 postgrads to work. Things like this were tried during the first Trump administration. What do you think the lessons are for the immigration legal community, from that first go around, where with an issue like this that's going to impact, I mean, every Fortune 1000 company and all the, many of the clients of thousands of immigration law firms?
And really quick, going into it, I have the numbers. They are 20% of STEM workers. They are 40% of advanced degrees in STEM, 26% of doctors, 16% of nurses, 40% of home aides, and that's probably not on the OPT side. But obviously, international students are coming, and they are studying STEM way more than Americans.
Yeah, and I know I've seen articles periodically that call out, the number of founders of companies that came out of STEM OPT, went to H-1B, got green cards, and are now, what's the economic multiplying factor of them starting their business in the U.S. and employing
45% of Fortune 500 companies are immigrants or children of immigrants.
There you go. It's so economically this would be, I think, just a bomb going off. And also, it's all going to boil down to what's the influence of the sort of Fortune 100s on the on the policy making. And we know that initially there was that whole battle between Elon Musk and Stephen Miller.
Oh, yeah.
And then, interestingly, didn't realize that they actually had a relationship before where Musk was funding Miller. So the extent to which that's going to sort of tip one way or the other, I don't know. But my suspicion is they're not going to do it, or at least they're not going to probably. If they did anything, maybe they'd try to reduce STEM OPT back to what it was, something like that. But to completely eliminate all of OPT, I just don't see it happening.
This seems like a further escalation of their battle against higher ed in America. They did all these SEVIS revocations, and it was so hectic. And now they're saying, well, what else can we do? And it seems a bit crazy to me, considering the international students paying the higher rates of tuition are supporting the higher ed industry in America. Many universities across the country would not be able to survive were it not for the additional revenue coming in through international students paying tuition.
Wow.
And if you look at organizations like NAFSA that are talking about these things and saying how much it would hurt the economy and hurt their industry if we had a significant decline in international students. But it doesn't seem like the Trump administration really cares about that industry, and in fact seems like they want to be adversaries to universities and institutions of higher ed.
Yeah, that's a really good point. I mean, just look at the funding that they're withholding on, somewhat flimsy pretexts and the amounts, whatever it was, $3 billion from Harvard for research. And that's not even going to be going to hearing till July. So, yeah, I think you're right.
Seems like they're looking for leverage to say, hey, like you need to reform the way that you do higher ed, that you do education in America. And here's another thing. We could take away work authorization from international students. And then how are you going to get tuition from international students?
Right.
Yeah, it seems like it's a bigger behind the scenes conversation than just the immigration rules and regulations itself. Because for a little background, Joseph Edlow previously held roles at USCIS during the later years of the Trump administration. I think he was chief counsel, and then he was a deputy for policy. And then the last few months, he was actually sort of quietly the acting director of USCIS. So he's been in the organization before, and he knows how it operates. And then in the intervening years between 2021 when he left and now, he had his own consulting practice, like most former government employees do. He had his own law firm, and then he was also a fellow at the Heritage Foundation, and he's a contributor to Project 2025, which had a very robust sort of roadmap for the desired policy agenda of the Trump administration when it came to immigration. This was not in there. Removing F-1 OPT was not a part of that. So it's interesting that it just sort of came out of the blue. And like you said, Matt, if you pair it with what ICE has been doing with SEVIS revocations to F-1 students and now threatening it for F-1 OPT holders, it seems like there's a thread that's going to be pulled there. And then last point on that, and I'll go to the next clip, is that, and Dan, you know this super well. Matt, you know this well. Every immigration attorney who is listening knows this well. The three chances that you get in the H-1B cap lottery if you're an F-1 OPT and STEM OPT holder is crucial, given how difficult it is to get selected in the registration, right? So a company
I
being
have
the
close friends that they weren't selected and they had the three chances, and then they go back and get masters, so they get additional chances.
So a company being able to employ somebody for those 3 years and they have work authorization for those 3 years as they're trying to, nail down that H-1B is crucial. And then so the next clip I'll show here is Senator Chuck Grassley asking Edlow about um, uh, H-1B fraud and abuse, which is sort of the poll-tested talking point that all Republicans and members of the Trump administration are using right now. So I'll play that, Dan, and then we can sort of get your reaction to this one.
Workers. So how would you fight fraud and abuse in the H-1B program when you become director?
Mr. Chairman, thank you for the question. In terms of fraud and abuse in the H-1B program, it is absolutely pervasive, and it's something that in the first administration we attempted to handle via regulation. Unfortunately, that regulation was vacated. If confirmed, I look forward to moving forward with additional regulations and sub-regulatory actions, but also I do have to commend you and Ranking Member Durbin for introducing legislation to bring attention to this critical issue, and I want to be a partner, if confirmed, with
Okay, he's just sort of placating Grassley there. But Dan, two things I want to ask you about. One, what is he referring to with the regulations and sub-regulations that they tried to put in place to combat H-1B fraud and abuse that is apparently a massive problem in the first Trump administration? And two, what do you think that means for when he's ultimately confirmed, what immigration lawyers are going to start seeing in the subsequent months?
Well, I think one of the issues is the fraud and abuse came about due to the H-1B registration regulation that the first Trump administration instituted, which we talked about on your session, your lawfully session last just a couple days ago. So that was where they saw the massive spike when all these companies realized they could create a cottage industry by having a phony baloney petitioner company that would allow one person to submit like umpteen registrations and effectively create a 100% selection rate chance for themselves. So that, and I can't remember the exact numbers, but they were pretty staggering. So the fix came in the subsequent year when they made it such that you got one registration and it was keyed to your passport. So you couldn't have multiple registrations going into the lottery. So that, to my mind, was a massive spike in fraud. Outside of that, the program itself, and I wish I had the statistics at hand, there is no widespread fraud. I mean, there's so many guardrails on the H-1B program to begin with. Like you have to abide by a prevailing wage, that has to be certified by the DOL. The one time that I ever saw an H-1B visa revoked for fraud, it was a legit fraud. The person had, unbeknownst to anybody, made up their diploma certificate. It didn't actually exist, and somehow that skated through. Like I think it. I mean, we're not 100% experts on determining whether something's a real document, but that was one time in probably 25 years that I've been doing this that I saw a case of fraud. And I'm sure there are FDNS, the FDNS officer statistics out there, but I've never heard that, oh my gosh, it's so pervasive.
Yeah, and during his time at USCIS during the first Trump administration, and this continued under the Biden administration, the number of pages in most of the immigration forms increased. The fees increased. The barriers to apply for an H-1B visa or for any visa have increased substantially over the last decade. Matt or Dan, you could take this question, but do you think we'll see a return of something like the public charge rule, or maybe something similar to that will in their mind maybe start to filter out more of this supposed fraud and abuse in the H-1B system?
First, what I want to say is, the irony, and maybe it's not so much an irony, but the hypocrisy that we see within the Trump administration is that they talk all about government efficiency, But I guess that government efficiency does not apply to immigration. In fact, when it comes to immigration, let's increase regulation. Let's increase the burden, the cost. Let's make it all more difficult and add additional regulation on top of already a highly regulated process. The H-1B and many other things that you're going through to get immigration benefits, it's so much. It's too much. I've heard, I've been working in immigration for around 10 years. I've heard that before my time, Dan, you'd be able to comment on this. Like the forms were way shorter. Like the forms have gotten so long over the years, and the government is asking for more and more and more information. And the public charge is an example of that. That form, what is it, the I-944? That is it's so invasive. It asks every single thing about your financial life. It knows more than your credit report. It asks all of your global assets, all of your global debts. And you shouldn't need to provide that level of information to the government for them to make a decision around your benefit. And I don't think if you look at the regulation, they're not asking for such a high level of proof to determine that you will not become a public charge. And in my time working in immigration, I have never seen an example of someone becoming a public charge. And so it just seems like it's just like what we were talking about earlier with these rejections at the beginning of the funnel of the immigration journey. The public charge is another way to say, hey, how can we make this harder? How can we make this more restrictive? How can we make this more regulated? And if I were to guess, they're for sure going to bring it back. It seems like they started with other things before coming to USCIS, but now it seems like we're entering the phase where they're going to start bringing some of their policies and ideas into USCIS.
Yeah, it's nuts. Like, so as you're saying, like, it's the public charge threshold is $21,137. Like, how many H1, like, by operation of minimum prevailing wages, I don't think there is a profession that even at level 1 that would qualify for a specialty occupation would be 21,137. So it's like, why are you wasting everybody's time? Because you can show proof of, what your actual pay is, which they have to pay you as part of the H-1B process. But it's not about efficiency. Again, it's always about slowing down and always about the statistics looking better for, tapering off immigration, basically.
Yeah, so I think for any immigration attorneys who are listening, this isn't going to be a surprise to you. You've probably known this since the election day happened, but this confirmation hearing is just greater confirmation to you all that what we saw in the first Trump administration is likely going to be coming back in force as soon as Edlow is confirmed and is officially at the head of USCIS, which should happen any week now. Okay, guys, final 2 clips I want to show you, and then Dan will jump into the trend or story that you think isn't getting enough attention. This one is from Senator Chris Coons asking Edlow a question about the green cards that were wasted under his oversight when he was at USCIS. It was actually one of the more informed questions that I saw a senator ask this time. So we'll listen to this one, and then I want to play one more clip right after it, where Edlow talks about his biggest priority for USCIS, and then we can get both of your reactions and wrap up here.
Mr. Edlow, if I might, between 2020 and 2021, over 80,000 employment-based green cards for legal employment here in the United States went to waste because the then USCIS leadership didn't adjudicate them, resolve them on time, and that sparked bipartisan concern. Do you agree that wasting green cards that have been authorized by Congress is unfortunate, and these opportunities for legal employment shouldn't be missed? And as director, will you prioritize reducing unnecessary paperwork and improving processes to improve legal employment here in this country?
Senator, thank you so much for the question. In the last 4 years, I've had the privilege of serving in the private sector, and I've seen the need to modernize forms in a way that I never really understood before. If confirmed, I plan on making major gains to modernize our systems, both for vetting and screening purposes, but also to allow attorneys to better send in forms as opposed to still using paper forms, to be able to scan them and then that information be taken in through a PDF process. So
Thank you.
absolutely.
Thank you.
Okay, so that sounded good, right? I think for the most part, all that sounded great if you're an immigration practitioner. But I want to just jump ahead to a question he was asked by the senator from Alabama.
This is
Uh,
something we were talking about yesterday. Is the Trump administration going to continue the digitization efforts of the Biden administration? And it sounds like from what he said, yes.
right. And then this is yeah, I'll play it and you guys can hear it out, and then Dan will go to you for a reaction on both clips.
Knowing that, knowing your previous work, what do you see as your vision? What are your big priorities, if you are confirmed?
No, thank you, Senator. I think the big priority has to be the reduction of the backlog.
Okay.
That backlog has grown to insurmountable levels over the last 4 years. When I left as the Deputy Director of Policy in January of 2021, there were about 450,000 affirmative asylum cases pending around the country. That number has grown. There's over 1.5 million now. Now, what does that mean? That means that all these extra people have gotten into the pipeline, and that's only for asylum. Mm-hmm. We also have green card backlogs and other, as the senator alluded to, other employment-based green cards that we need to look at too. However, the real problem that I see is I don't know who's in the backlog. For me, backlogs are more than just a bipartisan talking point about how we got to get the agency in order. I think it's of course important to get someone's benefits to them as quickly as possible so that they have the certainty, and if they're able to begin a life in the United States and assimilate, that's fantastic. If not, they need to know that certainty and to move forward. However, the real problem with the backlog is that we don't know who's in the backlog because of the lack of screening.
How do you propose we find that?
So it seems like he cares about backlogs and wants to reduce backlogs. My question, if I had the chance to sit down with him, and I would say, do you care about all backlogs? And or are you going to go form by form and benefit by benefit? And we're already starting to see that. And we've seen executive orders come out of the Trump administration saying that they don't want to be moving forward with adjudication of 485s for folks that are coming from certain eligibility categories like asylum. So we were looking at some of the numbers yesterday from what USCIS has released, and we know that backlogs are growing significantly they were growing significantly under Biden for the 589 and some of these other categories where the backlogs seem to grow infinitely. And so what will they be doing for not only the benefits that they care about, but all of the other benefits that theoretically are part of law when it comes to granting green cards or non-immigrant visas for all of these different types that of immigration that maybe they align with and maybe they don't align with.
Dan, what do you think? There's some good stuff in there, but obviously, and we didn't even get to these clips, but he started his introduction to the hearing by talking about how the primary focus of USCIS under his stewardship will be for it to be a partner as an enforcement agency alongside ICE and CBP, which obviously is not what the agency historically has done.
What Congress says it should be doing.
Yeah. So what do you think about what he said there, Dan? What do you think it means for how he's going to steward the agency?
I mean, I think it's all going to go back to how can we slow processing? How can we increase denials most efficiently, right? And everything that they're doing is sort of trying to accomplish those two things, right? So you have, reported large-scale moves of USCIS adjudication officers into ICE and into FDNS. So you're already restricting you're making the machinery smaller that can process these things. And we all know that. And that's why you see the backlogs developing. And then, but you also have, him talking about, as anybody would, no one's going to come out and say, we're deliberately going to make this system worse. I don't think you can say that publicly, but they have the tools now. We know that they do to be able to do exactly what you're talking about, which is go category by category or maybe all at the same time. If you had the right, development roadmap, they've got H-1B electronic filing finally, and it mostly works, even though it didn't for a few days last week. You've got the PDF upload ability to be able to file that way. They seem to be serious about making the whole attorney role in the process of electronic filing better and being able to process G28s that will allow us to sort of be in that process. But then, the other question I have is, sure, you can reduce a backlog, but what's the adjudicative outcome of the
Right.
reduction of that backlog?
Our
Whole bunch
RFE
of
rates.
denials,
Yeah.
like, is that
Right.
what it is? I
And
don't know.
it's all well and good if you can, file petitions online and save yourself a couple of days via FedEx. But if RFE rates go back up to 30 or 35%, like they were in 2017 for H-1Bs, for example, that's going to just slow everything down altogether, no matter what. So I think that's something that luckily at Lawfully we can sort of see the signals before they happen, before USCIS releases data on RFE rates, and we'll be tracking very, very closely.
Yeah. I also have an article coming out, I think in a few weeks for AILA about all of the different, well, it's mostly focused on what immigration practitioners should know about what the different federal agencies are doing with artificial intelligence and other sort of technologies that specifically impact immigration attorneys. But obviously, it has to do with the adjudication as well. And there's a lot, like, there's the Palantir contract that was reported a few weeks back. I mean, the whole idea is going to be to, I would assume, especially if we look at the SEVIS revocations as an example, just sort of connecting data sets like a fire hose, basically, and very quickly adjudicating, if you want to call it that, because it's not really adjudicating, just mass sort of revocations, mass denials, things like that.
Yeah. Okay, we'll wrap it up there with the news. But Dan, before we say goodbye, we wanted to give you the chance to sort of share a story or a topic that you think is undercovered in the immigration space right now. So tell us what you got.
Welp, my big concern now is now that they've looked at F-1 visa revocations, are they going to turn their attention to other categories like H-1B and that sort of thing? And my suspicion is yes. I haven't heard a whole lot about that. I mean, we heard about those weird RFEs where people were told to come in, the beneficiaries on a petition to come in and have biometrics done, which makes no sense because they don't really have a direct, I mean, they do have a stake in the petition, but they're not the petitioner. They sign nothing. And they're going in, and everybody was scared they'd get, taken away by an ICE officer because they had some kind of criminal issue, similar to the F1s, where those criminal issues seem to frequently be that they were victims, and it was somehow included in the NCIC data, but they still had their statuses revoked. I think we could start seeing that in the H-1B context too, because they've got that same database, right? And they can hook it up with the Department of State visa data, and there's not much that would stop them because the discretion in DOS to revoke a visa is pretty broad. They could start doing that. So one practical tip I saw somewhere was make sure your email address from your DS-160 is always up to date with the consulate, because you'll have no way of knowing that your visa was revoked, thereby making you potentially removable if it's not up to date and they can't let you know of that fact. There's like no other way to know that until it gets to USCIS and they send you a notice. But that could be months down the line from when that happens. So you may be in a vulnerable status and not even know it. So that was one little tidbit.
No, it's really interesting and something that I think unfortunately practitioners have to keep an eye out for. I'm personally really grateful that we have some great litigators out there, like Brad Bannis, Stephen Brown, the Impact Litigation guys, so many others who are able to get the communications that are happening behind the scenes of the Trump administration released as part of their litigation. So we're able to see how these things are coordinated. And it helps us sort of identify some signals for Dan, like you said, how it might happen in other areas and start to impact other immigrants as well. Matt, any other final thoughts on that or anything else?
I'd just say that if you want to be more in the know of everything that's happening with all the different government stages, and you want to have access to real-time data and the trends that are happening within immigration, reach out to us at the Lawfully team. We are really excited about what we've built with Lawfully Pro and what we've got upcoming. It's we're doing something that has not been done before in the industry, and it's getting better every single day.
Awesome. Well, we want to thank our guest attorney, Dan, for being the first to come on our weekly immigration news recap. If you're an immigration attorney and you're listening to this, you want to join Matt and I to chop it up about the immigration news of the week, just reach out to me. My email will be in the description of the podcast, and you can reach out to me on LinkedIn as well. Dan, Matt, thanks so much, and we'll see you next week.